Laura Lalíková, Belle Beems, welcome to PhD Café. It's a series which I'm honored to run with my good colleague and friend Magali Eben. We invite PhD researchers doing competition law and digital markets to share with us their experience, on the substance to discuss their research, but also how does it feel to do PhD these days. So perhaps we probably start. Let me pass the floor to you, Magali. Maybe you can invite the first round of questions.
It's really great. I love the series, and I'm really happy to have Laura and Bella here. I think it would be nice if Bella, you started by introducing yourself and also your project briefly, and then we can delve into asking you questions. But first, tell us who you are and what you're doing.
Thank you so much, Oles and Magali, first of all, for inviting me to be here. It's an honor, and I'm looking forward to discuss mine and also Laura's research with the two of you today. My name is Belle Beems. I currently work as an assistant professor at Leiden University, but before this, I did my PhD also in the Netherlands at Radboud University. And there I wrote a PhD, a monograph, which I defended very recently, in fact, in January this year. So it's all very fresh still. And somehow the question setting reminds me of the defense, which was a great experience, to be honest. So I'm very much looking forward. That's me. Then a bit more about my project. I wrote a book on the intersection between competition law, the GDPR, and the Digital Markets Act in markets for personal data, or the application in markets for personal data. And I mostly took an institutional perspective, meaning that I focused on the overlapping competences of different enforcers, in particular the Commission, national competition authorities, and national data protection authorities, and the ways in which they cooperate to apply those frameworks more or less coherent in the digital world.
That's great. Maybe before I delve into your questions, Bella and Oles does too, maybe it would be nice to hear Laura introduce herself, because then it's a little nice to hear. Laura, you might have questions for Bella as well. So go ahead and introduce yourself.
Yeah, sure. Thank you very much. Again, thank you so much for the invitation. I'm very excited to be here today. And it feels a little bit of a full circle for me because I remember at some point I met Bella at the beginning of my PhD research as well. So it really feels nice to kind of have another conversation with her, but in a different setting. Yeah, I'm also a PhD candidate in competition law, of course. And currently I'm finishing up my PhD and at the same time I'm lecturing. So that's always interesting to see how you can also, try to translate your knowledge into a way that students will understand it. And yeah, my research focuses on essential facilities doctrine and the concept of public services, and how and to what extent both of these approaches can be used to safeguard access to digital platform infrastructures/services, and whether one or the other can inform each other in any way. So I'll delve into that later, I'm sure, but basically that's the gist of it.
Fantastic. Thank you very much, dear Bella and Laura, for introducing yourself and your research. Now let us focus on the research of Bella, and then we will focus on the research of Laura. And then at the end, we will look at the more kind of socio-legal aspects of doing PhD these days. So the research of Bella, if you are invited to present your research in a couple of minutes, your monograph, indeed, your PhD thesis, would you be able to squeeze the most essential information into this short period?
Yes, it's always challenging, of course, but I'll give it a try, and I'm sure we can zoom in on the more interesting details in our conversation. So my PhD essentially consists of three parts. And what I did in the first part, I included the methodology and also my definition of personal data markets. So I explain how those markets work and what makes them different from more traditional or brick and mortar markets. In the second part of the PhD, I elaborated on my hypothesis that in those personal data markets, the instruments of competition law, the DMA, and the GDPR increasingly overlap. So I explained conversion in a way of different regulations. This trend works slightly different in my view for the GDPR than it does for the DMA. The overlap between competition law and the DMA is very much the result of all the attention digital and personal data markets are getting from lawmakers. And lawmakers introduce novel instruments that to a certain extent overlap with regulations that are already in place. The DMA is a very clear example in this regard because it resolves certain competition law shortcomings. It looks a bit like competition law, but still it's formally not a competition law instrument. So there we see an overlap between competition law and something that sits somewhere between competition law and sectoral regulation in the traditional sense. For the GDPR, the overlap is more created by the new economic reality. Because on those personal data markets, we see that data, also personal data, is increasingly being monetized. And as a result, personal data is no longer only relevant from the fundamental rights perspective of data protection and privacy, but it also becomes a competitive parameter. And thereby it enters the realm or the field of competition law. So a different trend, but also an overlap. Then in the third part, I zoomed in on the more institutional dimension, because all those different legal frameworks are enforced by different actors, either at the national or at the European level, or somewhere in between in a network or a cooperation framework. And what I try to do, or what I did, it's done, so I did it. What I did, I mapped how the different fields, so competition law, DMA, GDPR, overlap, and which tools we have available to resolve those norm overlaps. So firstly, I looked into mechanisms of preemption and hierarchy of norms, because my assumption is that if one of the fields takes precedence or is superior in terms of hierarchy, there's no real norm overlap that may lead to difficulties, since it's very clear which instrument should prevail. Then, secondly, I found that in this digital market situation, norm hierarchies are in itself not sufficient. Because what we don't want to resolve clashes only. We want to apply all those different instruments in a complementary fashion in order to regulate those markets effectively. And how can we realize the potential synergies between the different fields? In order to do this, we need frameworks for cooperation. And in my research, I found that for some types of cooperation, this is very well developed. The European Competition Network functions, for example, quite well. But for other, mostly cross-disciplinary forms of cooperation, this is still very challenging, and we don't always have the necessary frameworks available. So that's what I did. In a nutshell, I mapped overlaps, then institutional arrangements to resolve overlaps, and I analyzed those in light of the normative benchmark of coherence. So coherence was really the underlying theoretical framework for this PhD.
I mean, the logical question then to follow up on that is, what is coherence, Bella? How do you articulate what coherence means here, and its dimensions? Because it's an interesting normative benchmark, but I'm assuming different people identify it in different ways. So what did you use as your benchmark?
Yes, that's a very good question, Magali, and I think in every PhD it's a challenge, right? To identify and provide the criteria for how you're going to measure the normative standard or benchmark you applied. I built partially on existing research within the field of competition law, and combined this with insights, more theoretical works on coherence. So I relied on Wolf Sauter's work, for example, but also used work of Kress, who identifies more theoretical criteria to measure coherence. Then how did I do it? I subdivided coherence into different building blocks. Firstly, I assessed consistency, and that's, in my view, a more narrow concept than coherence, since it focuses mostly on the absence of clashes. Absence of clashes, I already mentioned the complementary relationship is not enough in this context, so I needed something else. That's why, secondly, I looked at cohesion. And cohesion is broader, also more difficult to measure, but it focuses on the degree to which different frameworks can collectively serve certain overarching relevant objectives. To apply it to the institutional framework, I broke this criterion of cohesion down even further into sub-benchmarks, if you will. And I argued that an institutional framework is coherence from a cohesion perspective if it's comprehensive and complete. So if there are no gaps in the framework that can be identified, if it provides an answer for every potential situation. And secondly, and that's very specific for a more cross-disciplinary analysis, and it ties in with the hierarchy of norms I just referred to, I looked at articulateness. And what is articulateness? That means that there should be explicit mechanisms in place to resolve potential conflicts between different norms within your theory or your framework. So that's how I did it. Basically, it was a 2 or 3 step approach. I first checked consistency, then cohesion, which I subdivided in completeness and articulateness.
And I also have a follow-up question. This all sounds amazing. So I wanted to add another kind of dimension to this structure, to this intellectual construct. I would see the ambition and the doability of this, the feasibility of this in a static world where we do it for the sake of academic purity, so to say, where we try to reconcile things which are being driven by very different objectives, essentially. But I imagine that with such powerful players trying to interpret rather, I wouldn't say open textured, but rather flexible provisions of the DMA, GDPR enforcement of them, of these provisions, we have this kind of continuous dynamism, and the stronger the muscles and the ambition of those interpreters are, the shakier the structure becomes, or it has to be resilient against these attempts to bring it into different to serve different purposes. Do you think that the proposed structure is robust enough to kind of to tackle these different winds coming and earthquakes, or it's not the purpose of being so omnipotent?
Yeah, that's a very good question. And the resilience of the overarching framework, so not only competition law and the DMA, but everything we have in place to address issues associated with those tech giants, that is the biggest challenge. In my view, the consistency or coherence of the framework is part of this resilience. Because if the framework is not coherent, the integrity is lacking. And if that's the case, the different branches of the framework weaken each other rather than that they strengthen each other. And that will ultimately undermine the overarching objectives and the effectiveness of the framework. Of course, coherence is not the only relevant benchmark here. In the end, it's also about efficiency. I decided to focus on coherence because my PhD is quite legal and doctrinal in nature, and I covered 3 legal instruments in 3 different legal orders. I looked at the EU, the Netherlands, and Germany, which was quite challenging in and of itself. So therefore, it wasn't feasible, or I couldn't maintain the focus if I would have added an empirical component as well. And I felt that going from my state of the art, my research question, I couldn't really judge effectiveness without endorsing this more empirical approach. So, but I see it as an interesting avenue for further research that could build on what I have been doing in the PhD project.
Building on Oles's question, your work is really fascinating, and I enjoyed reading through it. The thing that stood out to me is that you say it's not just a matter of substantive coherence, it's also institutional coherence and institutional capacity. And there is, of course, the static view of coherence across different norms. And often that's about substance, what we've all agreed that certain norms can and cannot do. But I think the institutional part probably is the more important one in terms of dynamic evolution, right? So I don't think it is possible for us to, or maybe it's idealistic for us to say we need a clear rule on the objective of each and every piece of law, and it needs to stay in its lane. It might be more probable that there's an agreement across different players on how they deal with each other and conflicts between their enforcement activities. When I was reading through your work, you say that the principle of sincere cooperation is interesting, but it's not enough. And I think here that might be an interesting thing to bring in. So why do you think this principle that we have in the EU, that, you know, the different authorities should cooperate with each other, the different member states, but also different authorities within the EU, and why do you think that principle is not enough? Surely it's an expression of trying to avoid conflict. Why is that not enough?
That's a very good question, obviously, and it dives very deep into the analysis. The principle of sincere cooperation is undeniably super important. It's the backbone of basically every cooperative arrangement we have in the EU, right? It underlays the European competition network. It underlies cooperation and the consistency mechanism as enshrined in the GDPR. Then, why is it not enough? That's mostly a practical matter. We know from experience, both in the field of competition law and in the field of the GDPR, so intradisciplinary experience within the separate or the respective bubbles of those 2 legal fields, that we need something more to realize cooperation in practice. We need a forum where authorities can speak to each other. We need a legal basis to exchange evidence. Experience with the GDPR shows that we even need something much more concrete, namely deadlines, to make it effective. So in the ideal world, of course, this broad and very general obligation to cooperate would be sufficient, but interdisciplinary experience shows that we need more concrete tools to realize this cooperation in practice, and even more so in the individual case. Then, if we zoom out and focus on cross-disciplinary cooperation between data protection authorities and competition authorities, it's even more complex, right? Because we have to reconcile objectives that may be overlapping, but are most certainly not identical. And then I'd say it's naive to assume that we can realize a more difficult form of cooperation with less tools to do so. Of course, the Court of Justice invoked the principle of sincere cooperation in the Meta Bundeskartellamt case as a foundation for cooperation. And in my view, that's a step in the right direction. We need this foundation as we don't have anything else. However, if we do want genuine cooperation in the future, especially at the case level, we need something else. We need more, namely a forum in which authorities can talk to each other and a legal basis to exchange evidence in individual cases.
And I'm very satisfied with the answer about the need to make your model also sustainable systemically, and not to look too much at the empirical aspects, because you do a comparative analysis and it's primarily a theoretical kind of examination. But we are not at the viva defense, we are just at the real life discussion where things are urgent. And thus, I imagine, and I'm sure, there will be big demand from different stakeholders in terms of learning from your model and maybe instrumentalizing to some degree it. And thus, my question is of kind of practical nature. We obviously, Bundeskartellamt Meta case, we see how the infringement of one can be seen as a proxy to infringement of the other area of law. But what if they are in direct conflict? What if we hear so well orchestrated and elegantly tailored arguments about security and data protection used as a shield against providing access to access seekers, business users, and indeed competitors within the DMA framework? Some of them are real, others are obviously exaggerated. Do you see practical application of your approach to these kind of cases? Should we also invite business users to consult your work in this regard? And
Yeah, I
gatekeepers, perhaps.
Yeah, I think it has a relevance for sure. First of all, because I take the hierarchy of norms perspective as well. And if we would have a direct clash, this could help. It would ultimately be the Court of Justice, of course, providing an answer on direct clashes. Having said that, I would argue that at the moment, a lot of frictions that are presented as a clash are not really a clash in nature. If we look at the privacy sandbox and the transparency ATT cases, it's not so much a conflict as it appears, right? Because the actual problem is that the gatekeepers or the big techs require a higher level of data protection from other players than they do from themselves. And then, in my view, the clash that may seem apparent could perfectly be resolved in the remedy stage, right? So you can work your way around it, and therefore, in my view, it's more of a friction than a clash. Of course, if we were to have a case in the future where data protection objectives and competition law, the DMA, cannot be reconciled in designing smart remedies, we need a weighing and balancing approach, and that would be up for the Court of Justice. And from a hierarchy of norms perspective, it will be tricky, especially if it's a clash between Article 102 TFEU and the GDPR, because the GDPR as secondary law would obviously be overruled by a treaty provision. But then the GDPR is also grounded in the Charter, which means we would have a clash between two instruments of primary legislation. And there we would need a much carefuler approach of weighing and balancing, perhaps even an approach that reminds us of the weighing and balancing we know from the Four Freedoms in case of clashes with the Charter.
But if I can continue very quickly, let us take an example, Article 8.1 of the DMA, which tells that the gatekeepers have to comply, but in designing their compliance protocols, they have to be mindful of other legislation in particular, and they refer to different, like I think GDPR and some data security stuff, etc. Do you think it would be feasible from purely juristic perspective to put the DMA in the kind of hierarchical primacy over other legislation, or it would be futile, and even without mentioning this requirement, this would be implicitly present in the defense protocols of the compliant companies?
Yeah, that's a very good question. I don't think there are clear indications to give a very superior position to the GDPR or to the GDPR nor to the DMA at the moment, right? Because indeed they sit at an equal footing, and undertakings have to comply with both. Of course, if a real clash were to arise, the GDPR is again grounded in the charter. So it could be more fundamental from a certain perspective. What is really difficult at the moment is that we have plenty of novel regulations that refer to each other only with a without prejudice clause. But those are very vague at the moment because what does it mean to be without prejudice? Does it mean that the GDPR should take precedence in case of a conflict? Or does it mean that the DMA does not limit the scope of application of the GDPR? And I think this is the biggest challenge. So defining what without prejudice means in practice. And this could be something to take up in joint guidelines, for example, as we have seen for the DMA and the GDPR now. I think that's an important step in the direction of a more cross-disciplinary and cooperative approach.
I want to come back to the without prejudice, but I had another question first, so I'll ask that one first. So far, we've been talking really at a high level, right? So a clash between, say, an obligation under the GDPR and a clash with an obligation under competition law. But there's also, I think, a reason why we're having confusing discussions is not necessarily because of conflicting obligations, but because we're using the same terminology in different contexts. And I mean, I see this in class now, where I tell students a word in when I'm talking about the DMA, and then another word when I'm talking about competition law, and they look like I've just like clobbered them because it's the same word, different meaning. This, I think, is a very difficult one to resolve. And I wonder if you had any views on this, particularly, for example, when we look at after the Meta, Bundeskartellamt, Saga, what if the NCAs now feel emboldened to take concepts that look like GDPR concepts, like power imbalances, for example, and use them differently in competition law? Do you think that's a risk? And does your research say anything about that?
It goes a little bit beyond the scope of my research because it's more of a substantive question, right? What do different notions mean in different contexts, and is the EU legislator coherent in and of itself in this regard? I mean, they strive towards coherence, right? We have Article 7 of the TEU. However, in practice, you mention the things you discuss in class. It's much more difficult because indeed similar principles have different meanings, and this should be taken up by the legislator in an early stage. I think at the moment in the entire procedure, the interrelationship between instruments is often overlooked or not considered sufficiently. It's of course taken into consideration, but the elaboration on the relationship with existing instruments and tools is usually rather limited and very brief at the substantive level. Then if we look at the institutional level, it's often entirely absent. So that's even worse in a way. For the integrity of the overall system, it would be better to have a certain degree of coherence. And I think here the guidelines, and especially joint guidelines, are very useful because, like you say, if the national competition authorities in the different member states become too bold, borrow GDPR notions and provide a very different interpretation, it will be very messy. Of course, the Court of Justice has a role to play there as well, because this to some extent could be resolved in a preliminary reference procedure. However, that's at the very end of a procedure, and ideally you'd have proper cooperation in an earlier stage to prevent this from happening. So there, I see a very clear interaction between the substantive and the institutional questions, because if we have a good institutional framework that can safeguard and guarantee a sufficient degree of cooperation, we can prevent incoherent substantive interpretations from arising.
I mean, you're right. They're trying hard. The EU legislator does try to have some coherence, and one of the ways they try is something you already brought up, right? So it's the looking at the start when you adopt a new piece of legislation, how it might, relate to other pieces of legislation and try to avoid clashes. You talk about the without prejudice clause in the DMA or wording in the DMA. Your work also looks at Article 3 of Regulation 1 2003. So there's an attempt here by the EU legislator to figure this out. Now, do you think it's done well? Are there some problems with the current approaches, both in the clashes between competition law, but also the clash between competition law and the DMA? Is there some way that you think the legislators can improve?
Yeah, I think there's definitely a room for improvement. I mean, you mentioned Article 1516 DMA and also Article 3 of Regulation 1 2003. I know you've been writing on this as well. So actually, I'm very curious to hear your opinion, because in my PhD, I relied quite a bit on the things you published together with Or. Very interesting analysis. Article 3, Regulation 1 2003 and Article 1516 DMA are an incredibly difficult read. I spent so much time in trying to understand, map, and structure those provisions, and I think this is a very concrete example of a situation where we have similar notions but are not sure what we mean, right? And this has to do, in my view, more with preemption of national laws than with hierarchy of norms. It's not so much about resolving clashes. Those provisions focus more on the room that is still available for national legislators to adopt additional regulations. And that's super unclear at the moment, because in determining this, you must know whether a national instrument qualifies as competition law. That's used both in the DMA and in Regulation 1 2003. In the regulation, no definition whatsoever. In the DMA, some kind of definition, but then can we apply it across instruments? So if anything, I'd see room for improvement over there, providing a very concrete definition of competition law at the EU level and stressing that it's an autonomous definition. And for now, from a coherence standpoint, it would be reasonable to follow the definition that is provided in the DMA. Of course, it's not bulletproof, because in the development from traditional competition law to the DMA to Section 19A of the German Competition Act, there are a lot of hybrids or even chimeras, right? The dichotomy isn't as clear-cut as it used to be before all this digital regulation, but at least providing a definition could be a step in the right direction. And then if cases would reach the Court of Justice could provide further guidance as to the interpretation of this definition. But at the moment, even the definition is lacking, as you uncovered yourself as well.
Magali, do you have any quick answer to this challenge?
I mean, I have the legal answer and then I think more realpolitik answer, right? I think legally you're right. I fully agree. I think there is a problem of notions and clarification on definitions of things, not just what is competition law, but what constitutes stricter rules and so on. There are some things that we see across different different tools and different legal sources that tell us what these things are, but they are themselves not coherent. But I thought your angle of preemption is a very important one, because what it's really about is about whether we trust that the different national authorities and the Commission, the EU courts, will basically consult each other and work together. So if you have a tight-knit group of authorities who are constantly talking to each other and who are willing to step aside when somebody else says, actually, I think this is my domain, then it doesn't matter that competition law is unclear. It matters because we've got not only 27 member states and the EU level, but many authorities on all these levels. And, we can talk about their incentives, but they don't always have the incentives to step back, let somebody else come in, or to be coherent with each other. So I think there's a lot of important work to be done. And I'm glad, Bella, I was reading what you wrote, and I think it's a very, very good first step. There's work to be done by academics and the courts in formulating what these things mean. There's far more work to be done, I think, in the actual political sphere, in agreeing that we need to work together. And sometimes that means that one authority puts their ego aside and lets another one take action. That's not something that I think you or I can fix, to be honest. But yes.
And I propose to move from one stellar PhD research project accomplished already to another one. Leaving so many questions unanswered, but obviously that's a normal condition for academic world, and these questions will be driving search for future answers. So we still leave many things untouched in this conversation. But let us now move to you, Laura. And again, as with Bella, let us invite you first to present your scholarship or your PhD project in a couple of minutes, please.
Yeah, which is always difficult indeed. Bella did such a wonderful job, so it's difficult to follow up on this, but I'll try my best. So as I said, the question that I'm researching is how and to what extent can either the essential facilities doctrine or the concept of public services safeguard access to digital platform infrastructure / services. And the way I approach this is I'm also going to do it chapter by chapter, kind of, as Bella did. I found that very, very enlightening. So essentially what I do first is I address essential facilities doctrine, and I look at how does it operate? What is its operation currently at? What is the status quo? And obviously that's very doctrinal. And then I move on to, okay, so what is its utility in safeguarding access to digital platforms in infrastructures or services? And there we get into, of course, the discussion that can now be labeled as access restrictions, right? So obviously there has been these proclamations of Bronner is dead, essential facilities is dead, and there is an argument to be had about that, right? So in terms of its utility in digital platforms, is there utility for it left, and to what extent, right? Well, I kind of look at it from a reverse angle and say, well, why don't we think of it in a way that the essential facilities doctrine has responded? And it has responded in a way that it had allowed for these distinctions from it. So I think I tried to be more positive about it. And I think that what this development, what it shows is that it actually enforced or protects the undertakings that need protection the most. And all these access restrictions can be seen as a consequence of that. So we see a more refined application of Bronner to a more refined circumstances. Then I move on to concept of public services. Again, I try to define how it operates, which can be a PhD on its own, I believe. But I try to kind of systemize it into 3 levels or 3 elements. And I say that this is sort of the concept of public services at the EU level. So I look into 106 derogation in form of SGIs. I look at Article 14, which provides for a legislative opening in this domain, Article 36 CFR-EU, and Protocol number 26, with the latter 3 kind of creating this constitutionalization of the concept at the EU level. And then the 3rd element, which is sectoral interventions, and I specifically zoom in on universal service obligations. So that's sort of how I display the operation of the concept of public services at the EU level. And then I move on to, again, well, what is its utility? How can we utilize it to safeguard access to essential digital platform services or infrastructures? And that's where I actually take the example of search engine services, and I try to run through an SGI designation and how that would look. But my main focus is actually on utilizing universal service obligations in the realm of search engine services. And that is sort of how I try to highlight the utility of the concept. However, then there is still the question of, okay, can this be pushed? Can this go further, and to what extent can it go further? And that is obviously my normative question, and that is where I rely heavily on the normative standard which has been introduced by Hans Miklitz, and it's the concept of access justice. And I use this concept to try to, first of all, map and actually explain the developments that we are seeing in essential facilities doctrine, and as well in how we see for instance, the concept of public services operating at the EU level. But I also use it to see, well, is there room to go further than what we are seeing right now? Or should we go backwards? And that is what I set out to do in chapter 4, which is on my normative framework. And then chapter 5 is what I call convergence. And I try to bring essential facilities together with the concept of public services under this umbrella normative vision of access justice. And I try to find these synergies, these convergences between the two of them. If they are both motivated by this concept of access justice, what does that mean for their future? And can one or the other inform the other approach? And that is essentially the core of my research. And obviously, this research project is also part of a grander research project, which is entitled Modern Bigness, and it's run by Professor Anna Gerbrandi. And that the premise of that project is, and therefore my starting point of my project is also the fact that we're seeing that big tech companies are in possession of market power that does not, however, only manifest in economic domain, but you can see that it transcends into social domain, political domain, personal domain. So if we see this trend of this market power transcending into these other domains, the question is ultimately of this overarching research project, shouldn't competition law do the same? And that's kind of the motivation as well behind my research project.
I'm glad you brought up the Modern Bigness project because it is very clearly the normative underpinning of this work.
Yeah.
And so that's what I want to ask you to unpack this a little bit more because, well, I was going to say some of these underpinnings might be controversial, but I want to say they're less controversial in 2026 than they were like in 2016 or 2006. But for the still-wordy, die-hard economic efficiency crowd out there, can you unpack a little bit more? You know, you're talking about there's this thing where the power goes beyond purely economic or market-based concerns. And you're saying, you know, access to justice is basically bigger, in my understanding, than just safeguarding access as we normally talk about it in essential facilities and competition law. Why competition law here? You know, why not completely go and say competition law is irrelevant here, or and we focus on public services, or basically why this normative assumption and how does it impact on your discussion? So
yeah,
you're trying to reinterpret the narrow interpretations that we've previously had, right? So can you talk a bit about that?
Yeah, I think that's a very good question. Why competition law, and should it just not be left on its own? But I think there is an argument to be had that competition law is part of a bigger framework. It's embedded into bigger values than itself. And if we look at the history of competition law, we see that that was kind of an intention of those at the beginning, right? To see corporate power as as a broader issue than just market power. And I think the competition law can really kind of be used in tackling other concerns than the narrow concerns that we're normally faced with. And I think I don't see I don't see an issue with going further if it actually has a normative justification. And that's kind of where my starting point is if this can be normatively justified, if the rules can stretch and it does not go beyond what is predetermined, why not? I think the question back should be indeed why not? What is, except apart from, of course, the predictability of the narrow mindsets, but apart from that, I don't think it's something that cannot be managed.
I also wanted to ask you a question, Laura, about practical dimension of your model. How do you think it can be used by stakeholders primarily in competition law discussions and litigation? What's the real life implications of the ideas which you elaborate?
I would say the practical implications are not as present in my research, as I think I'm more looking at it from a much broader perspective and trying to explain these trends. However, in any case, I think there's still a discussion to be had about, okay, what are the limits of essential facilities doctrine? Right now, we know that there's a discussion going on about Android Auto, right? This concept of openness, open infrastructure. I think we still need to, and there is a lot to be had, and we need more work in terms of discussing the limits of what is openness, right? This seems to be the starting point for Bronner now. It's the initial design of facility. Okay, but what does that mean? So in that sense, I think this work can also help in that regard, give more context to how openness should be determined, assessed, or how it should be delineated. In terms of public services, for instance, I think my work has more practical relevance, because I think I take especially the concept of universal service obligations and I apply it to a specific scenario which I think has not been done before. And I think I open the conversation for stakeholders and for those involved to actually enter that room of thought and start having these discussions, but start having them on a more concrete level. Because I think what's happening, especially with the public service concept and the application of public service to digital platforms, is that there is a certain hesitancy to do that. And I don't quite understand why. Because I think if we look at, for instance, a good example is DSA, and the DMA as well. The DMA you can think of as providing wholesale access, what we would normally see in sectoral regulations. But the DSA has some hints and inclinations towards what could be seen as a public utility-like regulation. I mean, it asks the platforms to provide, for instance, one recommender system that is free from profiling. That, to me, screams public service interest, right? There are inclinations in the DSA to a certain, well, you could say still negative obligations, but certain obligations on the DSA for platforms to be aware of what political impact their platform has on democracy, on election systems. So why, if we already have these ideas in something like the DSA, what is stopping us to go further and to address issues like affordability, like quality, like continuity, like ensuring universal access? That is where I think my work can have an impact on stakeholders, because I think we can actually start sort of putting those topics on the table and actually apply them in a way that could be useful.
Loads of thoughts, but
yes.
What you're arguing about public service kind of approaches is really interesting. And you can see that maybe the hesitancy comes from the fact that these companies started out as private companies. There's no kind of state intervention dimension to start with. But actually, one of the angles that your research seems to be taking is not really looking at whether there's an evolution of, from state enterprises to market-based, but rather to focus on a lower level, namely vulnerability. So I was looking at what you sent us, and you were saying, there's a parallel in vulnerable customers when it comes to universal services, and then vulnerable undertakings when it comes to essential facilities. And I think that's a really fascinating angle. So I was wondering if you could unpack that a little bit more. So why is your focus on vulnerability kind of as a assumption here?
Right. So the vulnerability stems from, and I would like to also return to maybe at a later stage to actually what you said about how I'm not addressing the fact that this is a private power coming from not former statutory monopoly framework, because it's an interesting topic, and I would like to address it as well. But in terms of the vulnerability, it's based on the concept of access justice that I'm using as my normative benchmark, because the concept essentially has three requirements. One is breaking down barriers to market participation and access. The second is enforcing procedural safeguards. And the third one is institutional design. That is what the idea behind access justice is. It is what represents the social outlook of the European project. Now, I focus on the first requirement, breaking down barriers to market participation, or to participation in society as well. Now, if you look at that can be subdivided into three other principles, which would be materializing access, given meaningful access, ensuring fair and non-discriminatory access, and the third C level that I call it is ensuring that vulnerable are safeguarded from exclusion. Now, this vulnerability originally sort of, as has been introduced by Hans Miklet, kind of has also roots in universal service obligations, right? That's where we see a very clear manifestation of vulnerable being protected from exclusion. Being protected from exclusion because it is acknowledged that their access to whatever public service is in question is essential. Okay, so we want to make sure that those basic access guarantees are safeguarded. Now, actually, Miklet also refers to McGill at some point during his discussion, where he says you already see this tendency to safeguard against exclusion in McGill. Now, if you twist that around, you can say, well, essential facilities doctrine essentially operates on that C level of protection. So it provides the basic guarantee for undertakings as to not be excluded. And the limiting principle is indispensability there. And that's where I make the argument of, yes, currently the limiting principle is indispensability. That is how we define vulnerable undertakings. But if you were to make that jump, and if you were to say, okay, but if access was sought to an infrastructure that operates in a sector of essential critical needs, could you make an argument that indispensability should be replaced or omitted or understood as we need access because this concerns also essential critical sector? So, and thus also bringing the citizen's perspective into evaluating indispensability through, of course, the prism of undertakings. And I would say that it does not go that far as people think it does, because we already see this idea of openness, of also regulated access. If you have access that is regulated, indispensability does not have to be fulfilled. So if we already have this idea of open infrastructures, and indispensability does not have to be fulfilled. Regulated access, it does not have to be fulfilled. I argue that if there is a dominant undertaking that chooses to operate in a sector that where the dominant undertaking risks being there is a high risk that it will be regulated or there will be a competition intervention, the incentives can be equated to the same level of incentives that the dominant undertaking has when developing an open facility. So what I'm trying to say is bringing in this citizen's perspective through access justice, sort of, infiltrating it, but it doesn't go that far off from what we already see in competition law to begin with.
If you bring the DMA dimension to this context,
Right.
would it be feasible? So let me just elaborate what I mean, because if we talk about the main beneficiaries of the DMA, we would definitely identify among stakeholders either parallel or horizontal challengers or business users. So would this model presuppose that business users using this vocabulary in order to strengthen their entitlement to access specific or force the gatekeepers to comply, or we bring the voice of end users directly to the discussion? And if the latter, wouldn't it be the case that the gatekeepers could also operationalize, as is the case when we've been discussing Bella's research, privacy and security, gatekeepers can equally operationalize the concept, these universal interests of end users, claiming that they are in a better position to protect or to satisfy these interests?
So if we look at the DMA, and I think this kind of definitely boils. It hits one of the criticisms of looking at big tech platforms or their infrastructures, their services as sort of essential. By doing that, what you do is also entrench, or there's the risk of entrenching their power further, right? And as opposed to trying to make sure that you create an environment where you challenge that power. And I think that is definitely a risk. However, I'm of an opinion that I don't think it should stop us from having that discussion. And I don't think if we bring the citizen's perspective into the discussion, I don't think it's going to be detrimental to citizens. I think highlighting the citizen's perspective can actually bring the discussion to a different level, and we're starting to understand the power and the transgression of this power from one domain to another.
So whilst I am listening to you, Laura, I think you're creating an opportunity for Bella here, because the more we expand competition law, right, the more we expand norms in essential facilities doctrine, the more likely it is that competition authorities are going to step on the toes of other regulators, right, and vice versa. So you're creating more work for Bella, which is nice. She can write more and more. But I was also wondering if you have kind of reflections on each other and on this. Is there a way that we can bring things together coherently? Is there a way that we can say, okay, you know, what is a legitimate area for competition authorities to be in versus public service regulators? And if you don't know, that's fine, but I'm just talking out loud. Because that becomes the difficult thing, right? We're currently in a situation where we've got so many things and more regulations coming that are all kind of addressing the same innate sense that there is something wrong in digital markets, and they're all looking at it from different angles. So are you doing this on purpose so Bella has more to write about? Is there any reflection?
Definitely not so that Bella has more to write about. No, I think I know that my research does not provide very clear-cut answers or answers that are going to satisfy everyone. But I think having this discussion where you compare essential facilities doctrine to public services also highlights, actually, for me, the deficiency of public service and how it is underused right now. So at least one sort of hat off that I can give to competition law is that it's responding, and it's responding really neatly, and it's sort of differentiating different circumstances from one another. And we see that it is acknowledging the market dynamics of digital big tech platforms. However, what to me is surprising that whilst we're having these deep conversations about how far should competition law go, we're not having enough discussions about what about public services. So I think, yes, I'm at the same time pushing competition law, but I think I'm at the same time also trying to say, yes, we know it's here, but there is this other thing that is not being looked at all, or is not being looked at sufficiently. So how about that we leave competition law alone because it's actually doing pretty well and we go somewhere else. So the point is also to not just put all the blame on competition law, but to kind of show that it's doing relatively well when you compare it to other avenues that are quite underdeveloped, I think. Yeah.
Great. Thank you very much. I think it's a good opportunity for us to pause. I shouldn't say to stop because there are so many things to discuss further. And I'm sure with life expectancy rising rapidly, we will have so many opportunities in the future to stop and discuss them in more detail. Let us now revert to the last part of our conversation, where we'll invite both of you to reflect upon your journey of doing PhD, more kind of sociological aspects. Maybe you have encountered some interesting elements of doing your PhD in the Netherlands when you've been in exchange or in communication with other scholars, young scholars who've been doing PhD in other jurisdictions. So maybe share with us some latest experience. Bella, let's start with you.
Interesting question always. And again, so much to say on doing a PhD either in the Netherlands or the entire dimension of going through the process while keeping your sanity. A big distinction between a PhD in the Netherlands and in other jurisdictions in the EU is, in my view, the degree to which you're part of the faculty. I know in the UK, PhD is more like an extension of your studies. And in the Netherlands, or at least for me, it really wasn't. Because in Nijmegen, I had a 25% teaching appointment, meaning that from a very early stage, already in the first year, you're really a faculty member and you're being seen as a colleague. And for me, that was very helpful, first and foremost, because it offered me a possibility to do something beyond the research in the PhD and to develop other skills as well, more skills of coordination, of cooperation, etc. And I found that very, very valuable from an early stage. Of course, it comes with the challenge of balancing your time. But I think, especially for someone who starts a PhD straight out of college or out of university, it is a good setup, right? Because in your PhD, it's your project and it's a huge responsibility to manage the entire thing. And therefore, I found it super helpful to see very closely how my colleagues were managing their tasks. And of course, not one-on-one, but I felt like I could apply it to my PhD as well. And the same goes for writing smaller pieces of work like articles or book chapters with more senior, more advanced colleagues, or even with your PhD supervisors. That was also something I found really, really helpful, because in the beginning, I had, quite frankly, no idea where to start with an article. All right. So it really helps to see and to monitor closely how more senior colleagues are approaching this. And I found that hugely helpful in the Dutch system.
Amazing. Thank you very much. Laura, can you continue, please?
Yeah, I think I can only second what Bella said. You definitely feel part of the department here in the Netherlands, so that is always a great plus. I had 100% research time, so I did not have the same experience exactly as Bella, but nevertheless, you know, I definitely was surrounded by colleagues that were able to help me. But I really think that what's key for anyone, I think, that's starting PhD, that and this is what I try to pass this knowledge to newer colleagues that come by, and that is to tell them, you're not supposed to know things right now. You're just started, so please just push yourself to go to conferences, push yourself to present, because nobody's going to look at you, especially when you're in the first year, and think, wow, they really missed something there, you know? And I think that is something that I think can be kind of daunting at the beginning. And I think that can kind of, if you get over that part, it can really help you to push your research further, because people will only want to help you. And I think another tip that I would give is, so look at your PhD. Obviously, this is the typical, not as a sprint, but as a marathon. But I think it's really does apply. And what I try to tell as well, again, to my colleagues that just started, is say daily goals and be happy with them. So if you tell yourself, I'm going to write 500 words today, and you do it, that's awesome. And it does not have to be 5,000 words immediately, you know, and you might have to rewrite those 500 words again, but that's part of the process, and that's okay. So yeah, I think those are at least my biggest tips starting with PhD that you can take on.
I love those tips. So Bella and Laura, I was wondering on the notion of tips. If you came across in some kind of weird time warp yourself from like a couple of months before starting the PhD, is there something you would say to that version of yourself? Would you be like, this was a great idea, do it, or please don't do it, it was a mistake? Which is, if that's the case, then I feel sorry, but also fine. Or is there something you would say to them to encourage them? Bella, you may start. I know it's putting you on the spot here.
Yeah. The first thing I would probably say would be chill a little, right? Especially in the first year, I felt so much pressure already, whereas you have so much time, and it's an excellent opportunity to explore, to go to conferences, to talk to people. But especially in the very beginning, I felt somewhat guilty if I weren't behind my desk working on the actual PhD. And my supervisors helped me there a lot, right? By saying there's more. It's also about your personal development. And there's more than this particular book. Another thing I would say to myself, which kind of relates to the chill remark, is you will be far more efficient in the last year, right? So in my planning initially, I kind of foresaw that I would be equally efficient each year, but that's just not the case. In the beginning, it's really a phase of getting to know the topic, getting to know people, and getting into it. Whereas in the last year, you're far, far more productive. So yeah, that would be my most important tip, both to myself in hindsight, but to PhDs starting their trajectory now. Take it easy and give yourself some room to breathe.
I think that's very, very valuable. Laura, what would you say to your slightly younger self?
Yeah, I would definitely agree with Bella. Indeed, relax. Your research proposal is not going to be at the end at all. So I think that's also what I always notice the first years that begin now, that they're so focused on their research proposal and trying to connect everything, which is great. But I also tell them, like, it's probably not going to be turn out to be the exact same thing that you planned it to be, and that's okay. And let it be that. Like, if there is something that changes to your plans, that's good. That's a good sign. You're making progress. Like, you're learning something more about your topic than you knew before. And I would just, again, talk to people, talk to your colleagues. Don't feel alone. Talk to your peers. I think we tend to feel that we're going through a lot of struggles alone, and that there is no way that my colleague X or Y is struggling the same way that I am. And then once you talk to each other, you realize, no, they're having the exact same issues that I am. They're having the exact same insecurities that I am. So it's okay. I guess if they are having it, then the other PhDs that already defended probably had it at some point. So it's just the same stuff for everyone, essentially. And again, one last tip that I would like to give, at least something that I wish I have done, is attended summer schools. Especially if you have, for instance, here we organize summer schools every year. And I think to myself, why didn't I just join a summer school in competition law and get refresher or get a different perspective from a different person who's explaining it in a different way, instead of sitting in front of a book and trying to, you know, absorb all the information myself. So something like that as well, I think is a good tip for anyone who's starting.
You know, it's never too late, Laura. You can still go to summer schools.
Yeah. No, if I'm organizing them, that might be difficult.
No, it's true. Thank you. Those were great tips. Your younger selves are thankful.
Absolutely. Belle Beems, Laura, Lalíková, Magali, Eben, and myself are very grateful for sharing your fantastic experience with all of us, but also and primarily for sharing with us your research. We look forward to continue discussing these issues in the future. Thank you.
Thank you so much.
Thanks.